Hey everybody, Derek Ruiz here, and I'm super stoked to be interviewing for the second time fabulous attorney Mr. Scott Schomer. And let me give Scott's background here. Scott P. Schomer has been certified as a specialist in estate planning, trust, and probate law by the State Bar of California, of course. He is a graduate of Boston University School of Law with over 25 years of experience. He has appeared on local and national television discussing the importance of estate planning, which is our topic today. His firm, Schomer Law Group, is a professional law corporation that specializes in elder law, probate, wills, trusts, and conservatorships. He has served as a member of the LA Superior Court Probate Volunteer Panel, Probate Settlement Panel, and a judge pro tempore, which I can never remember what that means. Scott's expertise has been recognized by his peers with such accolades as repeated nominations as a California super lawyer. Scott is also a fellow of the American Academy of Estate Planning Attorneys. Wow, very impressive. And welcome to our estate planning discussion today. Scott, welcome.
Derek, it's a real honor to be back with you. We had a lot of fun last time, and you're doing some great work here educating the public at large. And I'm honored that you'd asked me to return. So
Thanks, man. Well,
let's get to it.
these are important stuff, and as you know, I'm a real estate broker, so I'm talking to clients and people about this kind of stuff. It always comes up: wills, trusts, conservatorships, estate planning, and so it's really helpful for me to have somebody that I can refer my clients to because, believe it or not, Scott, I got clients that own multi-million dollar properties and they don't have an estate plan. The property is in their name. It's not in a trust. And I'm like, oh my God, do you guys want to go through probate? So, anyways, why don't you just start by educating our audience and just telling us what estate planning is, what it's all about, and why it's important?
That's a great place to start, Derek. One of the things that I jokingly and cynically refer to from time to time is that people spend more time planning their vacations than they do their estates, right? So, what is estate planning? We start with the first word, estate. Estate is a collection of assets and liabilities. So, you mentioned to me you have clients with multiple properties with millions of dollars of real estate assets. They're holding in their name that those things are all part of their estate. It's a collection of all of their net worth. It's everything they've worked for their life that they've, slaved away and skimped and made good choices to collect this wealth. And the planning part is just, is there a way that we can most effectively make sure that we minimize your taxes, protect the assets as well as we can, and get them to the people that you want them to go to when that day comes that you're no longer with us, right? Because I think I've said before, I haven't met any vampires, so we're all going to leave this realm at one point or another. So what's your plan to get your wealth to your loved ones, to your family, and help the next generation along and really build on the legacy that you've built? So that's what we're doing. We're sitting down and having a heartfelt conversation about how we do these things for you.
There's probably different parts of an estate plan, correct? I mean, there's
Right.
the trust, the will, medical directives. What are the different parts of an estate plan?
So it depends on who you are and what your assets are. What are we really looking for? The way that I try to simplify and break this down is we are really looking at planning for two possibilities. One is for the event of what I refer to as incapacity. The second one is the ultimate one, just like taxes. The second one is death. So when we're talking about incapacity, we're talking about your inability to handle your affairs. It could happen from a variety of reasons. You could develop Alzheimer's, you could develop bad Parkinson's, you could have a stroke, you could have a heart attack, or as I affectionately say, you could be hit by the bus and in a coma. And I laugh about this, but this has happened to people and families that I have helped. So if you can't write your checks. If you can't transfer your property, if you can't finish the refinance, who's going to do that for you? Who's in place to take over and legally has the power to do it? So there's a plan that we need for that. And then, of course, the asset transfer, we talked about that as well. So to me, in my mind, the most important documents of those two pieces are the incapacity documents. So you asked, what are the documents? The incapacity documents start with a durable power of attorney for finances, right? So can somebody, if you become incapacitated, write checks, pay bills, do things like that for you? The second related document is the healthcare directive, the advanced healthcare directive. Again, if your doctor looks at you and you can't articulate what your wishes are, whether you want surgery, who is going to do that for you? A third related document that can do this well for you is a trust or series of trust agreements. So in a trust is a standby contract that springs into action and allows a successor trustee to take over and do the same incapacity things at your incapacity if you're unable to do it. So, for instance, if you're in the middle of selling a piece of real estate and, as I affectionately say, you get hit by the bus or have a heart attack, you're in the hospital, your trust will have a provision that says my successor trustee can carry on, can close that sale transaction, and then put the money into my trust so it's there, it's safe, and we don't get sued for all that. So those are probably the three most important ones. Whenever you do a trust, you also need to do a last will and testament. Now you can do a will without a trust, but what a will is, the purpose of a will is it is a set of instructions to the probate court to be used when you're dead. So it is literally, I'm Scott, here are the assets that I have, here's what I want the judge to do with the assets that I have, and here are the basic rules. So the will is exclusively focused on passing assets after your demise. Now, a good plan, we look at all of these things together and coordinate them. And what we really try to do is get most of the assets, especially if we're talking about real estate, into a trust. So there's very little that's dealt with by the will, but it's still necessary. Last bit is there are some other related ancillary devices that you would know as such things as 401ks, 403bs, IRAs, joint tenancy accounts, or beneficiary accounts. Those are private expressions of estate plans. So in other words, if I go down tomorrow to Wells Fargo Bank and I open up an account and I say, here's $100,000, hold this money until I die, and when I die, give it to my wife, Colleen, then that is, in essence, a trust you have set up at Wells Fargo. So when we do good planning, when we look at estates, it starts with the word estates. So what are all these accounts? Do you have that account at Wells Fargo? Do you have real estate? Do you have all these different things? And then what are the collection of tools that we're going to use to make the management of your life and these assets easy, and to make the transition of the assets to your loved ones smooth and efficient when you're not with us anymore. That's the easiest way I would describe it.
Got it. And if I remember correctly, if your property's held in an estate, excuse me, your property's held in a trust, that avoids probate.
That's correct. That's correct in almost every circumstance. So let me just say a word or two about probate, because I think it does a nice job to do some contrast here, and that is you've asked me what are sort of the big five documents, right? Or big four. So I've talked about power of attorney, I've talked about healthcare directive, I've talked about a trust, I've talked about a will. Um, those documents, except for the will, are all generally designed to manage this process privately. You're not required to do any of them. The United States, God bless America, we have freedom. We have the freedom to do whatever we want. And one of the freedoms we have is the choice to do nothing, which I affectionately refer to as the freedom to make bad choices. Because if you die holding wealth and you've not made a plan, so you haven't put a beneficiary on that Wells Fargo account, or like you described your clients, they just own a piece of real estate in their name, then the system of last resort is the probate system. So briefly, what is this probate system that we're talking about, that you hear about? Simply stated, it's a lawsuit. So somebody has to, a loved one of yours has to step up and say, hey, Derek's not with us anymore. He has assets in his name. We need to move them to us. So they need to file a petition in the Los Angeles Superior Court in the probate department. It's the same filing fee as a lawsuit. It costs about as much as a lawsuit, in many cases, significantly more. And it takes a minimum of about a year to process the assets through the system. So essentially, the government will do this for you, but the government is going to make a decision about who they're going to put in charge of this process. There is a list of priority, but there's no clear, for instance, like, your brother may write in there and say he wants to be in charge, and you might say to yourself, oy vey, have you met my brother? He's terrible. I don't want him in charge. And then you end up with fights or all over the stuff. So you're not expressing your intent as to who you'd like to be in charge of your stuff. And there's a default as to how the assets get distributed if you've not made an expression, if you've not made an estate plan. So if you've not said, I want my assets to go to these people in this manner, then the government's going to decide how your assets get distributed, where they go. But the easiest way to think about this is you can plan for these things, or you can just leave it to fate, and the government has a system for it. And the government system is, we're going to go file lawsuits and you're going to be stuck in court. And it's truly no joke. I've been involved with families where we've had multiple lawsuits, 3, 4, 5 different versions of probate administration, because nobody sat down to do the planning, and the fees are exorbitant, the delays are exorbitant, the rules are exorbitant, and it's just, frankly, a disaster for the family.
In my opinion, that's like the number one reason to get your trust set up and your estate plan, so you don't have to go through probate. You don't have to put your family through that.
Yeah, I'll give you another really quick sort of measure of this, right? So probate fees are measured strictly on the value of the assets that are going through probate, right? And there's a formula set in the probate code. You'll find it at probate code 10800 for those geeks out there that want to look it up. But it's a sliding percentage formula. Your simple rule is that if you have about $1 million of gross value of assets, so I'm not talking about how much equity you have in your house. I'm talking about if your house is worth $1 million, which, what percentage of LA County homes, especially on the west side, are worth $1 million? Most of them. Your minimum fee to run those assets through the probate is about $50,000, right? I can do an estate plan. I can do an outstanding estate plan for a fraction of that fee. So $50,000. Now, what if your collection of properties was worth 2 million or 2.5 million? Now you're inching up towards $75,000, $100,000 or more in legal fees plus a year or more delay. I'll tell you a really quick, sad story. This doesn't have to do with real estate, but I had a widow approach us recently who lost her husband, a lawyer. Isn't that wonderful? Well, nobody can run a lawyer's business other than another lawyer. So the minute he died, which was back in November, all the access to all of his money, all his clients' money, everybody's access to all of his accounts is now frozen, and it will remain frozen. And the only thing we can do is we have to go into court and get a practice administrator. We have to get an administrator appointed, like an executor, who's another lawyer that'll take over and take charge of this. It's going to be at least a 4-month delay to even get started, to the point where she can even get some income out of what is arguably a family business, but she can't run it because she's not a lawyer. And then once we get this person appointed, the executive or practice administrator can't just start turning over money to the widow. You have to go into court and ask for permission, and the court has to be satisfied that the creditors are going to be paid, that all the other elements of your life are going to be dealt with and dictated. So,
Right.
yeah, no, it's you can't even imagine what a nightmare it can be. And listen, we're in the court system probably 3 days a week. I love the judges. I love doing the work, but I wouldn't wish my worst enemy to come along with me. Every family that I have to help through the court system, it always involves some level of heartbreak. So
Wow.
our strong preference is, let's sit down and have a cup of coffee. Let's talk about what your dreams, wishes are. Let's talk about who you want to protect. Let's talk about how we put the people that you love, trust, and respect in charge of the process so that somebody's there, and then let's set up a system to do it simply, easily, and way more economically efficient.
Let me ask you this question. What if an individual has no assets, no wife, no kids? What do you recommend in that situation?
So that's a good question. It really comes back to where we started. I talked about the incapacity documents.
Hmm.
So I talked about a durable power of attorney for finances and a durable power of attorney for health care. Um, so I talked about probate being a lawsuit. The related lawsuit that I did not mention is what happens if you have a stroke? What happens if you're incapacitated? Well, people have to treat you. Doctors have to know what what surgery to perform or what therapies to administer. They have to sign you into a home. They have to do all these types of things. And if you're not legally able to do that, again, it now falls to the state. The process for doing that is another lawsuit. It's called a conservatorship. Now, conservatorship may be foreign to your ears. What you're probably more used to is guardianship. It's essentially in California an adult guardianship, recently made famous by Britney Spears. If you followed any of that that horrible stuff, when folks come to me and say, I need to be in charge of my friend or I actually I received this call about 5 weeks ago with a friend who had a work colleague who had a very important role, had none of this in place, had a stroke, was there in the hospital. How do you manage his life? Your only choice at that point is to go to the government for help and file a conservatorship. And our basic estimate, usually you're looking, the filing fees to get one of those things started are over $1,000. That's just what you have to pay the court to get admission. You're easily going to spend over $10,000 a year to manage that. And everything has to be bonded, everything has to be accounted for. The court has to supervise whoever gets put in charge. It's really a hot mess. So
So, wait, let me
uh,
just,
yeah,
before I lose my thought.
yeah.
So, the question was, what if I have no assets, wife, or kids? You're saying that at the very minimum, you need to get a healthcare directive kind of thing going?
I would get a healthcare directive and a durable power of attorney, right?
Okay, at the bare minimum, if you have no assets, you're a renter, you don't have a lot of money, you got no wife, no kids, nobody. Maybe you have a family member, cousin, or somebody that could be named as the what do you call the person that would be in charge of you with a healthcare directive or something?
That person's called the agent or
The
the
agent.
attorney or attorney in fact. So
Got it.
let me spin out another one that'll be sort of more you know uh,
Okay.
home for you that I think will sort of put some flesh on the bone. So let's think about a tenant, an older gentleman that's living in an apartment that you own and that you rent, right? All of a sudden, bam, he has a stroke. Now the rent's not being paid, right? He's getting Social Security or he's getting some type of pay. He's got a little bit of money, not a lot. He's got a little bit of money, but he's okay. How do you deal with any of that? How do you, as the landlord, how do you serve him with eviction notice? How do you do the personal property auction? How do you get a call from his children? Hi, we want access to the property. Well, who are you? What legal right do you have to go into your father's apartment? It may be that your father hated you, right? I mean, it presents legal risks in all kinds of different directions. What if the kids call up and say, "Hey, I want to clean out all of Dad's stuff. I want to, for all you know, Dad has gold bars in the back of the apartment, and they're walking out the door with all his wealth, and you just authorized it by letting him in the door, right?" So we all need something in place that says, if I can't legally function, here's the person or persons that I would like to legally function on my behalf, right?
Got it.
That's sort of
Okay.
your key thing, because otherwise the government will eventually solve the problem, but it's a hot mess. It takes weeks and months. There's fights, there's court proceedings, and it is 10 times the cost.
So, what do you recommend to somebody who has assets but they haven't done any planning? They're just kind of winging it, and I see them all the time. I'm telling you, I'm always looking at title. I'm looking. Somebody calls me, hey, I'm thinking about selling, blah 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 blah. I go online, I go look on the tax records. I see guys that have 10, 15 properties all in their name.
Mhm.
So, what would you recommend to somebody in that situation if they want to get started and they're like realizing, hey, I'm 75 years old, I literally know a guy that's worth $10 million. Every property he owns is in his name, and he's been telling me, "Yeah, I'm going to get my trust. I'm going to for like 3 or 4 years. I'm going to get my trust done. It's complicated, and the guy Fallon broke his hip. I mean, he's towards the end. He's in his 80s. What do you recommend for people like that? And another question: why do people refuse to do it sometimes? Why do they just say to themselves? My theory is that they're afraid if they do estate planning, they're afraid that their kids are going to come after their ass. I don't know what it is. What's the psychology behind people who don't do that, in your opinion?
Oh, Derek, if I had to answer that question, I'd be a very, very wealthy man. You know what? I think it starts with the real basics. Procrastination. We all procrastinate. Nobody likes to go to the dentist either. But if you don't, there are consequences. That's sort of the way it is. That's one of the reasons I go to the dentist 3 times a year. That's your first problem. Your second problem is that this area is very archaic and it's very confusing. Even somebody as sophisticated and educated and with so much deep experience as yourself, you sort of look at this and go, what's the best way to go? How do I do this? Right.
Mhm.
So one of the things that we try very hard here at Schomer Law Group, and it's one of the reasons it's an honor to be here with you, is we try to get the word out and we try to educate people and make it simple and straightforward. So I can approach this a couple of different ways. Um, uh, one is if you want a really simple rule of thumb is that in California, if you own real estate, you almost certainly need a living trust. That's just sort of a basic foundational stuff. And when you do a living trust, you're going to want to do a pour over will and related healthcare documents, right? Now, how do I get that message out? The way I get the message out is I hold educational events. I have a very robust social media presence. I have a blog with over 1,000 posts on it where I talk about this stuff. I educate it. I try to get the message out. I try to encourage people to act and come see me. And I try to make it as easy as possible. So, if you come through one of my events or where I educate you, or you're a trusted colleague of, you're a client of somebody like you, Derek, you can call us up and I will sit down and I will give you, I feel so important about this, is I will set aside an hour to an hour and a half to sit down and get to know you and talk through all these issues. At a minimum, I'm going to educate you, but I'm going to basically walk you through and talk about how we do all this. I am an expert at making this as easy as possible for people and getting them over the finish line. So all you need to do is carve a little bit of time out of your day, come down and sit down, have a cup of coffee with me. Let's get to know each other. Let's have a conversation. I will figure out who you are, what's important to you, who you want to protect, and I will put together a state of the art plan that takes care of all that as efficiently as possible. That's my evangelistic message, I guess, is how I'd say it. Derek, I seem to have lost your audio. Did you?
What's better,
There
a
you are.
will or a trust?
That's a great question. So this goes back to our conversation before. Remember that if you have no will or all you have is a will is a set of instructions to the probate court. So that means in most situations, you are basically buying a ticket for a one-way trip to the probate court. Why do you want that, right? Why do you want to force your family into a lawsuit? Why do you want to delay distribution for a year or longer? Why do you want to lock up most of the money until the end of the probate so the family can't access it? And why do you want to pay 4 to 10 times the amount of fees and costs to be able to do that? What is a trust? Why is a trust better? A trust is a contract where you manage and you deal with all this stuff. It's a private contract. It is almost always, unless there's something really horrible or ugly about it, it is almost always managed privately. So you have a situation where mom dies, the successor trustee can pick up the reins, can often be put into the driver's seat. In other words, in charge of collecting the rent, managing the building, dealing with all that stuff within a couple of weeks. And we can liquidate assets, we can pay bills, we can deal with all this stuff. And I have literally administered, this is not the norm, but I have literally administered probate or trust estates soup to nuts in under 30 days, right?
Wow.
That means the person's dead and
Transfer title or
The
whatever.
transfer title. I've done everything, got everything finished within less than 30 days. Now,
And
doesn't happen in most cases, but that's how much more efficient it can be.
and I also see. I guess if I remember back, you said you don't have to do anything if you don't want. If you're in a trust, I've seen clients come to me to sell a property that it's still in their parents' trusts from 20 years ago, and they never did anything. They never transferred everything. They didn't. I don't know what they're doing or why they didn't do it, but I guess you don't really have to if you don't want to, right? Or they just neglected to do what the trust told them to
Right.
do.
That's this sort of falls into the category of a question of, is this legal? It's like, oh Lord. So yes. So your Let's run that hypothetical through. So your parents own a property and then they die and it's in their trust and you just say, screw it, I'm not going to do anything. So as I affectionately like to say, there's no such thing as the probate police. Nobody's going to drive around and arrest you because you didn't administer your parents' estate. I've had the same thing with people who died without a estate plan at all. They didn't file probate for 10 or 20 years later. It happens from time to time. Now, what are the downsides of that? Well, the first downside is if you're living or using the property, you don't legally own it, right? So, what issues come up where somebody might question why you have ownership or your ability to do things, including evicting tenants? What if you have to evict a tenant? Show me your title. Oh, I don't own the property. Whoops. Okay, we got an issue there. So that's our first basic problem. Our second basic problem goes to one of your favorite topics, and that is Proposition 13, Proposition 58, Proposition 19. What in the world am I talking about for normal people? I'm talking about the real property tax rates, right? So Prop 13 comes along and says, passed way back in the early 70s or mid 70s, that when we own a piece of property, we owe the county that it's sited in, Los Angeles County, approximately 1% per annum of the value of the property on an annual basis, right? In LA County, as you know, it's more like about 1.25%, and it can escalate a little bit. So the issue we have in these counties, of course, is that real values have gone way up. So you'll get somebody that bought a property for $100,000. They're paying $1,000 or $1,200 a year for taxes. If I came and bought that property today, it's worth $1,000,000. I'm going to pay $10,000 to $12,000 in taxes, and these folks just ignore it. So historically in California, we had something called Proposition 58. It's still there, and that's called the parent-child exclusion. And what it says is if you left it to your kids, they can enjoy the same tax rates, incredible benefit and burden. Along comes Proposition 19, which the voters voted on and approved by a very thin margin. And they basically said that they thought that rule was being abused. And so they put severe limits on it. And so what that means is if you have a property that's been sitting in a state or a trust for 20 years, because the law has changed, you may be penalized, and you may not be able to enjoy the benefit. You may sacrifice the parent-child exclusion if you don't handle it correctly, right? So
Wow.
yeah, so these are just some of the things. So
How many years? How many years? Is there a time limit of when you can do this transfer?
the assessor wants it reported within 150 days,
Ooh,
and in order to get 150 days of death, and in order to get the benefit, there has to be a declaration that a child is living in the property. If the child wants to take the property and treat it as a rental property, you don't get the parent-child exclusion anymore, right? So there's a lot of tricky nuances, and it's one of those things where if you don't sit down and at least have a conversation about what are your risks, do I really need to do something, right? So I mean, people come to see me. I never lock them. I never lock them up and say, you're going to do this thing whether you want it or not. Everybody has freedom of choice. But my job is to make sure you understand your situation, lay out the playing field, tell you the pros and cons of various ways, and make a recommendation. And ultimately, you decide. If you look at me and say, Scott, you know what? I don't want to do anything. I'm just going to leave it in my parents' trust, and I don't care. And it'll be my kids' problem when they die. Okay, you may be compounding it by three, but you have the freedom to make that bad choice, right?
right.
But don't ask me don't ask me to help you support it. I'm going to tell you the bad news, right?
Let me. Here's a real good question too. Why can't somebody just put their kids on title? and say you got say a client's got a house, it's worth $2 million. It's in West LA, and they don't want to do all this fancy schmancy title. I mean, estate planning and stuff. I'm just going to put my kids, Mary and Steve, on title, and that way, when I die, they're on title.
So you're asking a question that a whole bunch of people ask. It's a very popular question, and unfortunately, a lot of people do it. So there are a number of risk and potential problems with it, and it's one of these things. Where do I start? So the first basic thing is when you look at our practice, putting people on title is the largest source of litigation of any area that I deal with.
Really?
Absolutely, right? Because
Why is that?
everybody has sort of different ideas of what it means. So the first basic rule is mom wakes up and says, "Well, I'm going to do this easy. I'm just going to put my son on title." Okay? That's an irrevocable decision unless the son decides to give the property back, right? Have I had mothers put their sons on title and then say, "Oh, I need to do a refinance, or I want your sister to get more, or I want to do something else," and the son look at them and go, "I'm not giving it back. I'm part of the ownership." I have seen a whole number of families blow apart over this basic issue. And once you start litigating this issue,
Mm.
it's, you get out the checkbook because you can hit six figures in a flash of an eye. So that's problem number one. Problem number two, you may have the greatest kids in the world, right? However, your kid could have a judgment or a debt or a liability, right? Or what happens if you put kid on title and now kid's in a divorce? Now, suddenly, isn't this property part of his? Because he owns it. That's what putting people on title means, is they are a part owner. So could this thing get caught up in the kid's divorce? And could your soon to be ex daughter or son-in-law end up with a portion of your home? Does that sound like a good time? So that's another problem. The next thing is that a lot of people do this without thinking about the Proposition 13, Proposition 58 consequences. So it used to be a little easier to get away with this back in the old days, but especially now, when you file this, first of all, you got to notify the assessor that you're claiming the exclusion. A lot of people do this in their backyard and they have no idea how to do it. The second thing is that the son has to verify that it's his primary residence. So is the son truly living there, or is the mom just putting son on title and the son lives across town or in another state,
So
right?
wait, let me clarify this. So okay, I can see what the risks are that you described as far as things that could go wrong because the son or the daughter has debts or whatever.
Right.
But let's just say that there's no problem. Mom puts her son. Let's say mom puts her son on title.
Mm-hmm.
There's no issues, no legal stuff, no debts, nothing to worry about. Mom passes away.
The perfect family. Yes.
Yeah,
Yeah.
and then so now the son is the sole owner of the property, I guess.
Mm-hmm.
Uh, but I guess if that depends if it's a joint tenancy or tenants in common, or does it matter? Does that matter?
It
Or
does
does
matter.
that is it possible that mom's part of her ownership has to go through probate if it's not in a estate plan? So it can
So,
get really complicated, right?
oh yeah, yeah.
So
So,
joint if it's joint tenancy, then the son will automatically get the property, right?
so the term joint tenancy, the full name of joint tenancy is joint tenancy with the right of survivorship. So that is exactly what it means. It's designed to avoid the probate transfer. So from that aspect alone, it does work fine, and it does avoid all the mishigas of going through probate court. However, a lot of people will create deeds, and rather than putting them down as joint tenancy, they'll either leave it blank or they will describe it as tenants in common. Tenants in common essentially severs the interest, and now while the son may own half, the mother owns the other half, and that half has to go through probate, right?
Mom's estate owns that half.
Mom's estate owns that half, right? When mom's
Yeah,
mom's deceased. Okay.
right.
So, but but I want to go back and focus on two really critical tax issues, even in the perfect family, right? So again, let's use our basic hypothetical. Let's say mom bought a house in Venice in 1970 for $100,000, and today it's worth $1 million, right? And she says, "Well, I don't want to do that estate planning thing. I don't care. I'm just going to put you son on title." And son lives in Westwood or son lives in Oregon. All right, so they record the deed, assuming they do everything right and they put it down, and the assessor is going to write back and go, "Please have your son sign this verification that he, under penalty of perjury, lives in this property." The son's going to be like, "But I live in Oregon." And they might even say, "Show us proof. Show us bills with your name on. Show us your tax returns." When he can't answer that question, the son's half of the property is going to be reassessed. So mom has gone from having a $1,200 a year tax bill to a $7,000 or $8,000 tax bill overnight for the rest of her life. She's stuck with that, right? So that's problem number one. Problem number two deals with capital gains, right? So in order to understand this problem, I have to sort of explain to you the best gift that you get under the tax code is something called a step up in basis. You get it when somebody owns a capital asset and they hold it until they die. So again, using our $1 million property example, 100,000 acquisition, $1 million property. So mom buys it for $100,000. If she goes to sell it as a single woman and it's selling for $1 million, she has a $900,000 capital gain. Now, as her primary residence, she gets an exclusion of $250,000,
Sure,
but
sure.
all the rest of it, she's going to pay tax on. You're looking at a $200,000 tax bill, right? If she holds that property until the day she dies, her basis in the property, the $100,000, steps up to the fair market value at the date of death. So her basis in the property becomes $1 million. You're selling it for $1 million. That means your gain on the capital asset is zero.
Right.
That means she doesn't own a dime of estate tax. Of course, she's dead. The son doesn't own a dime of capital gains tax. No tax whatsoever. The problem is you break that if you give the son the property. When you give the son the property, if you give half an interest to the son, you're giving the benefits, a $500,000 property, with the burdens. One of the burdens is that low basis. So he's going to find himself with a tax bill of probably north of $100,000 when he goes to sell it. And so the question again then becomes, would you rather spend a couple $1,000s on doing an estate plan that can save you $100,000 in taxes, even without probate court? Or would you rather leave it to the fates, hope you don't screw it up, hope you don't reassess your real property tax rate, and hope you don't get smacked, or you will get smacked with capital gains tax because you didn't just sit down with somebody like me that can walk you through this and explain to you the best way to do it? To me, it's
Well,
kind of a
that's
no-brainer.
yeah, that's I never realized all the ramifications of putting a child or another family member on title, and I see that a lot. I sold 8 units last year, and the mom had cancer and terminal, and she just put her son on everything. Um,
Yeah, she threw away a massive tax benefit. Bam.
yeah,
You know.
yeah, she didn't know, and I didn't. Hey, she just came to me and said, "Look, my son's own." No, she gave her son 100%. She made him the new owner. She just quit claiming the property to him.
So she threw away the greatest tax benefit available. So what?
Fortunately for her, she took a lot. They took a loss on the property
Okay.
sale. So, but most of the time people aren't taking losses on real estate.
Right. Right.
But she had just purchased the property. Then the interest rates went up really high, and so it was a big.
Hmm.
But anyways, I see. Yeah, the ramifications of doing that. Now I can understand that and kind of guide my clients a little better not to do that.
Right. Right. I mean, if nothing else, look. Here's the way I think about it. Um, for especially coming through somebody who's a trusted advisor like you, my door is open. Right.
Right.
Come sit and have a cup of coffee. I typically don't. I typically will afford you an opportunity to let's understand your problem first, and then I, as I see it, I will suggest a solution if I think there is one, and I'll quote you a price, and then you have the freedom to say yes or no.
Yeah.
But you get to know me. I become a resource for you, and when we outline how much potentially I'm going to be able to save you and protect your estate, and how much better of a way to do it, hopefully it'll be relatively a no-brainer.
Yeah, well, I'm going to be, sending this interview out to, I don't know, about 3,000 people in my real estate database, and most of them are own apartment buildings. So, and I just know, and I'm going to tell them, guys, if you don't have a trust, call Scott today. So, anyways, I want to wrap this up. It's been about 45 minutes.
Yeah.
Let me see if there was one more thing I wanted to ask you. Oh, can't somebody just do their own trust? I mean, simple, or write their own will or whatever. We'll wrap it up with this question. What about people? Because I have had people say, "Oh, there's places like in LegalZoom or this or that, blah 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 blah," and I can just do all that on my own and save a few bucks. I mean, it sounds like penny wise and pound foolish. But what's your take on that? Somebody who's like going to wing it on their own.
Well, you said it exactly right. Um, what do a couple pieces of paper cost? I mean, paper's you know less than a penny in printing costs. That's not where the value is.
I'll just go to ChatGPT or something like that.
Right, right, and you don't even want to know the abominations I've seen in ChatGPT. Um, the 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 value of what we do is having somebody that has the wisdom experience to be able to guide you through the process and have you do just enough of the right things. Right? You can often screw this up way, way, way worse than you have any idea.
I
In
bet.
fact, I don't think I mentioned this, but I'm a professor of law at Loyola Law School where I teach trust and estates. And one of the first exercises I have with a room full of soon to be lawyers is I say, on the first day, write your own will, go. And we sit down and write them. And then I spend the rest of the semester going, so have you committed malpractice? Have you committed malpractice? Of course, I'm joking, right? Because they're not lawyers yet. But as they sit and learn all the little nuances and the tricks, you realize here are the six different ways that I have screwed this up because I think I could do this myself, right? So again, I've been down this path. I've seen almost every conceivable nightmare you can imagine. Bankrupt estates, high flying estates, all kinds of nuttiness, all kinds of family stuff. And my goal is to protect my clients, to get them over the finish line and make it smooth as easy as possible and to be there when they need me.
Yeah, I mean, it seems to me, and maybe I'm wrong, but it doesn't. I mean, let's say you own a house, and you got your 401k and IRAs or whatever like that. I mean, it doesn't seem like setting up a trust is that expensive. I mean, it's not like litigating litigation or anything crazy like that. I mean, you're not spending hundreds of thousands of dollars to write a trust or something like
That's
that.
right. That's right.
So I mean, it's crazy that people that own property or have a family that don't do that. So, but again,
Derek, you see these folks, they work so hard. They put their blood, sweat, life, toil into this thing. They've created this amazing thing. Just slow down and spend a little bit of time and make sure that we have it all in order and that we got you all protected. It's the greatest gift you will ever give your loved ones.
yeah. Well, great, Scott. That's a good way to end the conversation. Folks, if you're watching this video and you have not done estate planning, please give Scott a call. He'll give you a free consultation, I'm sure, and have a cup of coffee with them, and just tell him your story and who you want to protect and what do you want to protect and what you want to happen after you're gone from this earth. I mean, it's super important. So, anyway, Scott, thank you so much again. It's great talking to you because I learned so much every time we have a conversation, and I know that there's people out there watching this that need your help. So, I guess that's it. Any last thoughts?
Derek, the joy is the excellent level of questioning and your knowledge in this area. You're not coming to this blind. You've had a lot of experience and it shows.
Yeah,
And so it's an absolute honor and we had a lot of fun. So thank you again for inviting me.
awesome.
All right.
All right, everybody. Thanks for watching again. Reach out to Scott if you need some help, and we'll see you next time. Take care.